Now, views were expressed with regard to Udayanga Weeratunga in the political sphere today.
During yesterday's hearing at the Fort Magistrates Court, it had surfaced that the CID officers involved in investigating Udayanga Weeratunga's case had been transferred and that new officers had been appointed. Court has ordered the CID to obtain the services of these officers in the investigation of this case. The people of this country are suspicious as to whether a new set of officers had been appointed to tamper or sweep the previous investigations under the carpet. They thought that Udayanga Weeratunga may not be brought back to the country. It is the present government which has brought back Udayanga Weeratunga. We asked the JVP and the UNP to bring back Arjun Mahendran in the same manner. Our government is prepared to bring back anyone and show the people what is right. They assumed that Udayanga Weeratunga would be granted bail within a couple of days. That did not happen. He has been remanded. The State Council, who had studied the contents of this case for several years, has been transferred. At the same time, Chief Inspector of Police Francis and other officers who were involved in the investigation of this case had been transferred to Negombo after shutting down the Financial Crimes Investigation Division. As a result of this, it is a new officer who is tasked with investigating the case. This officer talks about sections 400, 454 and 457 of the Penal Code in court. He does not talk about Section 8 of the Public Property Act. This paves the way for Udayanga Weeratunga to be granted bail quickly.
පහසුවෙන් උදයංග වීරතුංගට අප ලබා ගැනීම සඳහා මාවත සකස් කරලා දෙනවා.
The government asked Udayanga Weeratunga, who was in hiding for 4.5 years, to come back as they are in power. They changed the protocol and produced him in court. The judge fearlessly stated what had been done was wrong and raised questions on why the officer who investigated this case was transferred. The judge also requested the IGP to utilize the services of this officer in this case. This is how attempts are being made to save an individual who had defrauded millions of rupees.
Meanwhile, the arrest of Udayanga Weeratunga was discussed in Parliament today.
I saw Udayanga Weeratunga being placed in remand custody. However, we thank the government for creating a country where a person like Udayanga Weeratunga would like to live in. The CID officer who conducted the investigations over the past 5 years was transferred. A new officer who was appointed to conduct the investigations comes to court and says that he does not know anything about the case. He had asked court what charges should be filed against Udayanga Weeratunga. This is how the CID makes submissions to court now. That officer doesn't know about this case. He doesn't know what charges to file against Udayanga Weeratunga, who caused a loss of 7 million to the government. Has the CID become infants? We would like to question you as to if you have made all the CID officers infants. The magistrate had publicly reprimanded the CID for their conduct regarding Udayanga Weeratunga, who caused the government a loss of $7 million. I am saddened that an officer under you is acting in such a manner. I have some knowledge on how complaints are filed and how they are removed. I do not think you can accuse a person of doing something just because a complaint has been filed against him. Investigations must be conducted. It is only after that you can take the rest of the steps. Just because someone files a complaint does not mean that the accused is guilty. There are many complaints about how the officer of the CID had conducted the investigations. The Fort Magistrate, who dismissed the bail application of former Sri Lankan ambassador to Russia Udayanga Weeratunga, made certain observations during yesterday's hearing. While pointing out the requirement to submit a certificate signed by a police officer above the rank of an assistant superintendent if the government had incurred a loss of more than 25,000 rupees, the magistrate queried as to why a certificate had not been presented in this manner while the government had incurred a loss of $7 million in the case. The magistrate noted the CID's failure to produce a certificate from an ASP, which is an essential document to prove the said deal is a crime committed under the Public Property Act, is a serious issue. The magistrate pointed out that the investigations took place for more than 5 years and that warrants were issued against the suspect as it was proven that the offences had taken place under the Public Property Act. Court pointed out that it is a serious issue that the suspect did not face any charges under the Public Property Act after being arrested and produced before court. The magistrate stated that it is unusual for the CID to have failed to submit a certificate confirming the offence under the Public Property Act and that it is evident that it had been done intentionally by the prosecution. The magistrate also added that court has observed that the investigating officers are conducting themselves to fulfill the bail conditions of the accused.